Welcome everybody to this children's seminar. It's my very great privilege to be accompanied by 4 professionals who are experts in their field, all of whom I have had the great pleasure of working with and continue to work with. So I'm just going to introduce the speakers one by one before we get started with the talk. In no particular order, I want to introduce Eleri Jones, who is known for her particular expertise and specialisation in relation to the operation of the maintenance regulation, Brussels 2A and the 1996 Hague Convention. Her work in the international arena also extends to reciprocal enforcement of maintenance and cases concerning the 2007 Hague Convention and 2007 Lugano Convention. Eleri is no stranger to awards. In November 2019, Eleri was recognised as International Family Lawyer of the Year at the LexisNexis Family Law Awards, and in March 2020, she was announced as the winner of the IAFL European Chapter Young Lawyers Award 2020. And this year, Eleri has been shortlisted for Family Law Junior Barrister of the Year. Welcome, Eleri. Next, we have Alev, also a barrister at One Garden Court, and Alev is known to many as a child law specialist whose busy practice encompasses the spectrum of private and public law proceedings in which she acts for all parties and appears at all levels of court. She has particular expertise involving the international movement of children and the separate representation of children, and she's appeared in landmark Court of Appeal decisions in both of these areas. Both the authorities of Reeve and Reeve are ones that I go to regularly. So thank you for your work in that, Alev. Alev has also been shortlisted for the Family Law Awards 2021 Family Law Junior Barrister of the Year. Next, I have the great pleasure of welcoming Roberta Ciaccini. Roberta is an Italian family lawyer with a vast international experience. Roberta is the go-to expert for many a UK lawyer in family law proceedings involving child abduction and relocation. In 2012, Roberta co-founded the law firm Ciaccini and Restignoli, and she specialised in areas of international law, international kidnapping and family law, as well as civil law. And finally, I introduce Amy Starnes, my colleague at Mills and Reeve. Many of Amy's cases have an international element. For example, where one parent wishes to relocate abroad with a child, Amy also advises on surrogacy and fertility law. Amy is well known for her sensitivity in cases which have intractable disputes with high conflict parents, issues of parental alienation, sexual abuse, domestic abuse, mental health issues, and drug and alcohol abuse. I'm very privileged to work in the London office of Mills and Reeve with Amy. So now moving on to our talks, we're going to have talks this evening on return orders post-Brexit and also on international relocation tips and traps. So with that, I will welcome my first speakers, Eleri Jones and Roberta Ceschini.
Very much good afternoon to everybody, and thank you, Zoe, for the very kind introduction. So Roberta and I are going to talk to you all about quite a discrete topic. It's about return orders in the post-Brexit world. We'll look at the situation effectively where a child has been taken or retained somewhere, and then the different options for trying to secure that child's return. We've got some PowerPoint slides which will help take you through our talk, and they can be made available to you afterwards, but instead what might be better is for us to distribute a short note that we've got which sets out things in a little bit more detail, save you all writing it down if it's of interest to you. So Zoe's kindly agreed with her colleague Claire to distribute that to you after today's talk. So for now, if you bear with me, I'm just going to share my screen so you can see our PowerPoint presentation, and then forwards, there we are. So return orders post-Brexit. Here's a scenario to put it all into context for you. We've got British parents, one child between them called Charlie. Until they separate, they all lived in London. That was their home. The mother has moved on in her life. She's got remarried and her husband is Italian. So mum spends lots of time in Italy with her husband, and Charlie does as well. And Charlie spends all summer with mum in Italy at baby. So mum wants Charlie to spend a little bit longer there, and they agree to spend the first term of the academic year for Charlie in an Italian school. But having had the baby, mum wants Charlie to stay much longer than just for one term and wants to keep Charlie in Italy. So retains Charlie there at the end of the first term, which is the agreement. So Dad wants Charlie to come home to England, live in England as was planned, and also spend the Christmas holidays with Dad. So what does Dad do? I'll hand over now to Roberta, and she will tell you what your options are.
Yes, good afternoon, everybody. So starting from the scenario that Eleri just described to you, we can consider that there are basically three options to evaluate, to decide, and to evaluate to decide which one can be better. First option is that of starting negotiations with the goal to reaching an agreement, a settlement of the matter. Of course, this is always the best option, but there are issues to be considered that we will see afterwards. Second option is instead of starting a litigation, which can be started either through the Hague Convention of 1980 on international child abduction, which means starting a proceeding for return of the child in the country where the child has been abducted. So will not be the country of the left parent. Third option is to start proceedings seeking return of the child to the habitual residence in the whole country. So in the country from where the child has been abducted. That in certain circumstances may sound more reassuring for the left parent because will be a proceeding in his or her own country. And this proceeding will be pursuant to the 1996 Hague Convention. And we will see next what are the pros and what are the differences between among these three options and what are the pros and cons of various options.
Thank you. Yes, and just before we move on to the options, we're just going to note briefly that we'll concentrate on using the references to the 1996 Hague Convention because that's where we find ourselves now in the post-Brexit world for new cases. But of course, if you've got ongoing proceedings or if you do want to recognise an order that was an order arising out of proceedings that started before the end of the 31st of December 2020, you will still be in the Brussels 2A regime. We're not going to spend time talking to you about that today, but that is covered in the a little bit more circulate for your reference afterwards. So as Roberta said, let's move on to consider what the differences are in those three options that we've laid out for you. Well, obviously, you would appreciate that if you don't go to court, if you're just doing a direct or mediated agreement, you then avoid court. One of the things we would just stress to you, though, is if you are going to do that kind of route where you're entering into discussions, if you are the left behind parent, one of the things you need to be careful of is not to acquiesce or not to agree to that removal or retention if that's actually not what you want or what you're not sure about. Because if you do want to seek a return order later, you need to make sure you haven't actually already agreed to the new situation. So obviously that's the difference when you're using the direct or mediated agreement route. When it comes to the other two options, the litigation options, with the 1980 Hague Convention, for those of you who don't know already, that is what we would describe as a summary procedure. It's supposed to be quick, and basically the premise of those cases is if you've got a child who's found to be unlawfully removed and abroad, that child should be returned unless the person who's taken the child can make out one of the set defences. And the key point here is that it's not a welfare analysis. And that's one of the key differences that you've got with the third point we'll come on to, And the idea of it is that it's the country that the child came from, the place where the child is habitually resident normally. It's that country that should make the longer term decisions. So it's a quick issue for getting them back to that place. Conversely, then, when you're thinking about the third option, it's sort of the other way around. Because that's the country of the child's habitual residence making the decision, they do make those decisions on a welfare basis. So it is a welfare analysis. It doesn't have a set timetable or even an aspired timetable. It's as quick or as slow as the law and the procedure of that home country allows. But the idea is that you ask for an order because of the circumstances for the child to be returned, and then you would apply to the country where the child's been taken for that order to be recognised and enforced under the principles of either Brussels 2A or the 96 Hague Convention as applies. The only other note that I might make at this stage is that there might be circumstances where you've already got a court order in place. And if that's the case, then you might already find that you've got provisions that say the child should be returned at the end of whatever period. And if that's already in an order, you might be able to move straight away to the recognition and enforcement stage without needing a fresh order. But just check, obviously, that the circumstances haven't changed in any particular relevant way. So now that you know what the options are and what the differences between those options are, let's have a think about what the pros and cons of each of them would be. So I'll hand you back over to Roberta.
Yes, the point is how to decide among these three options. The first option, the possibility to find an agreement with the other party. Of course, this can be seen as the best option because it reduces stress of litigation and cost of litigation. However, be careful because even if you find an agreement, it is advisable always to go to court to have this agreement ratified by the judge and put into an order, because otherwise the agreement is then not enforceable. So it is true that the first option reduces litigation. However, at a certain point, you will end up in court in any event, even if on a mutual consent basis. Also be careful with this first option because very often it is used by the abducting parent to delay the proceedings. So the abducting parent will engage in negotiations, losing time to delay the issuance of a proceeding. This is why, from my point of view, when I have to decide about the options, I'm always favorable, of course, to possibility of settlement. However, I always advise that in parallel, you launch the proceeding, either option 2 or 3. Why? Because this way, the negotiation will be true, will be motivated by the fact that there is a deadline, there is a hearing date scheduled. So will be real negotiations to avoid being in front of a judge at a certain date. So strategically, I encourage negotiations, of course, but it is necessary, in my opinion, in these cases to start the proceeding as well. Because it is true that, for example, under the Hague Convention, we have 1 year to start the application to ask for return. But it makes a difference if you do it immediately, quickly, immediately after abduction, or after a few months. It makes a certain difference, at least before the Italian courts. So this is with respect to the option of finding an agreement.
Before you carry on with that, I just want to endorse what you said about running two things in parallel and negotiating, obviously, at the same time as litigation. Just before you get to that stage, if you've sent a few letters maybe trying to work out what's going on, I would of course say bear in mind that it's quite possible that those letters may end up in front of a judge at some point. So bear that in mind when you're writing your letters and when you're planning what you're going to say. Don't say things that you might regret later, or maybe think carefully about what you're writing so that you can rely on it later, so that you're thinking strategically for your clients.
Yes, of course, this is a very good point. Option number 2, the procedure pursuant to the 1980 Hague Convention for return of the child. This is a summary proceeding. The convention says that it should be concluded in 6 weeks. Normally, in most countries, it takes a little bit more than 6 weeks. For example, in Italy, it can take 4, 5, 6 months to complete the entire proceedings, which is a long period, of course, for a parent who has an abducted child. But I can say it is a very short period if compared to ordinary proceedings, that at least in Italy can go on for 1 year, 2 years, 3 years. So it is a summary proceeding. As Eleri said before, there will be not any deep evaluation of the child. For example, in Italy, the most that can be done is an interview of the child at the hearing through the help and the assistance of a psychologist. The kind of defenses that can be raised in this proceeding are limited. It's a very technical proceeding. There are a few points that have to be discussed. The court doesn't, of course, go into the merit of the parental responsibility, who is the best parent. The abduction is analyzed. Whether or not there has been an abduction, whether or not the child has been wrongfully removed from the habitual residence. If the requirements are met, the child has to return. There is the so-called Article 13, where you can, where the abducting parent can make an exception that return can expose the child to physical or physical danger or mental dangers or an intolerable situation. But even here, it's a limited analysis that the court can do in very strict and limited circumstances. Normally, the proceeding works well, and in a quick, in a short period, you manage to obtain a decision. The third option is that of starting the proceeding in a home country. Of course, this may sound easier, especially for the parent who was the one left behind, because the proceeding will be in her own country. One has to consider that, however, once the parent gets the order will have, in any event, to be enforced in the other country where the child is. So there is always another step. There is always the problem of being at a later stage in a foreign court to enforce the order. The procedure is a little bit longer in this third option. And depends, of course, on the domestic rules of civil procedure of the country where the proceeding will be. In general, I believe that the second option is preferable. Personally, I prefer the second option to the third. Then the decision, however, it cannot be the same for all cases. I believe that every case is to be analyzed separately depending on circumstances. For example, in the scenario that Eleri described in the beginning, it was decided to choose the third option, but was a very particular situation where negotiations were ongoing during the proceedings, in parallel with the proceedings. Child was going back and forth between Italy and England, and therefore there was not the problem of enforcing the orders once the English court issued them. So the third option was certainly was preferable in that case. In some other cases, it may be preferable the second option because the proceeding is quicker and the enforcement of the order is going to be quicker and is going to be made directly on the child in the country where the child is.
Thank you, Roberta. I think what we've then tried to do for you is draw together some of the key considerations that both of us have covered throughout the points that we've said. Just to sum those up for you then, timing can be a real issue for you. So as Roberta said, the scenario that we set out at the beginning, you'll remember I said that the dad was really keen for Charlie to come home for the Christmas holidays because he'd been away all summer and the first term with mum, and he should have been, by the parents' agreement, spending Christmas with his dad in England. And so, you know, this being based on a real case, but for the purpose of the scenario, it was the case. The parents were able to agree that the Christmas holidays would be spent with dad as planned. So there wasn't an issue of having to enforce a return order so quickly for the start of the Christmas holiday, that there was some flexibility to consider the right procedure. Because, for example, to start the 1980 Hague Convention process doesn't happen overnight. And it would have taken a few, not just days, but potentially weeks to get into court in Italy to start that process. So by the time you even have one hearing there, the whole of the Christmas holidays has come and gone. Whereas we could get into court in England within hours if we needed to, but certainly within days. And you've got to think as well about those kinds of interim issues as well as the longer term issues. But that's the second point we'd say, is remember your longer term strategy, not just sort of where you want to litigate, including even what language you might want to litigate in, where the evidence is, the way that the court would analyse matters depending on which process you're using. But also, where's the enforcement going to have to take place? What are the enforcement mechanisms like in the place that you're considering litigating, or where the child is particularly? I mean, some of these cases, it's simply just an unlawful removal or retention and the child needs to come home. But in some of them, you're looking at a situation where one parent is basically wanting to relocate with the child and they're trying to steal a march and get that by the back door instead of going through the normal case where they would have to justify that removal and get the permission of the court if the other parent doesn't agree. So sometimes you can say, well, look, you know, do we really need to have a big argument about an abduction, whether it's a removal or a retention? Can we just all please come back and get on with this on a leave to remove application basis? And that's another reason why you might just want to carry on quickly by getting into your court at home, because you can then start that process easier, engage the local lawyers where all the information is and where all the people are comfortable litigating, and then crack on with that process. Again, as Roberta says, there's an element of needing to have the cooperation of the other side, because if they really wanted to make everything difficult, they'll force you through the abduction side of it first, maybe have a jurisdiction disagreement or something. But, you know, it's not necessarily always the case that people who've had an order made against them will have to have that enforced. Some people do obey orders, they just argue about whether the order should be made. So again, it depends on the temperament of the people that you're dealing with. So all in all, I think perhaps it's fair for us to sum up our advice to you in one key point. So I'll leave that to Roberta to say to you.
Yes. I agree with Eleri with everything she said, and an important advice is always to take advice from a lawyer in each country that is involved. And the lawyers should be in contact between them. Should be a teamwork to discuss the options, the strategy, and the prospects of the proceeding. The strategy to be decided may change depending on which country is involved, and because each country then has a different internal procedure, has different timing in starting the proceedings. For example, as Larry said, in the case that we are analyzing, that was involving Italy and England, One of the important issues was that it was possible to start the home proceeding very quickly in England, while Italy is certainly a little bit slow, even in starting a Hague proceeding that should be a summary proceeding. So in that case, the timing was a key point. But if the countries involved are others, the decision may change even on this basis. Another important issue to be taken into consideration is legal aid, because, for example, England provides to the left behind parent legal aid automatically because of the matter of child abduction. It's not the same in Italy. In Italy, legal aid is always linked to income. So you get legal aid only if you have a very low income, regardless of which matter is on the table. And so this can be also, of course, an important issue to be taken into account when deciding how to proceed.
That's a good point, actually, Roberta. Yes, because if you're thinking about the third option with getting an order to recognise and enforce it, it is fair to say that obviously if you're going to court in your home country to get an order to recognise and enforce abroad, or if you're then doing that step for recognition and enforcement abroad, you may not get any legal aid at all. Certainly in this country, you would get legal aid under Brussels 2A for recognition and enforcement of orders, but I believe there is no legal aid even in England for recognition and enforcement under the 96 Hague Convention, and that is the way it is now, unfortunately. So I did mention to you at the beginning that there would be a short handout that you'll receive. All of the points that we've covered, which have been very briefly mentioned in the slides, are set out in a little bit more detail in that handout. And on the second page, there is a very short breakdown of the difference between Brussels 2A and the 96 Hague Convention when it comes to using those instruments for recognition and enforcement of orders. Obviously, we are now in the post-Brexit world, so where we were previously, and still in some cases might be using Brussels 2A to recognise and enforce orders, especially orders made before the end of the transition period. For new cases that are starting now, if you're getting those orders and then recognising and enforcing them under 96 Hague, there are some differences you need to be aware of, so they're set out. And then I've also put at the end a list of some useful cases that the lawyers listening might appreciate. There's one CJEU case, and then a handful of domestic cases from the High Court and the Family Court in England and Wales, from different countries, not just EU member states, but others as well, where there's a question about which route you take, either using the 1980 Hague Convention or Brussels 2A or the 96 Convention as appropriate. So if you've got one of these cases and you're thinking about the pros and cons, that can be quite a useful list of cases for you to look through, to consider not just what your options are, but what the judges might make of it in the various different scenarios that there are in those cases. So that will be winging its way over to you electronically after today. But we hope that's been a reasonable, albeit short, introduction to some of the considerations if you've got one of these cases of an unlawful removal or retention. The child home, Charlie in our scenario, did come home over Christmas, and then guess what? There was a leave to remove application. So I hope that provides a reasonable segue for our next speakers and the topics that they're going to cover. But maybe I've spoiled Zoe's fun there. I'm sorry if I have.
You haven't at all. Thank you so much, Roberta and Eleri. Just listening to you both speak really brought home for me the importance of having experts such as yourselves involved on these really tricky cases. We have already had a really interesting question on enforcement of pre-Brexit orders, but I'm going to save questions for the end. So now we're going to move on to Amy Starnes and Alev. You'll need to just bear with me while I share my screen and the talk. There we go. Right, we're ready. Amy and Alev will be speaking to you about international relocation tips and traps.
Brilliant, thanks very much, Zoe. So first of all, I'm going to outline the approach the family court takes, And then I'm going to set out some tips and traps on defending such an application before handing over to Alev, who's going to focus on maximising prospects of success in making the application. So if we could have the next slide, please, Zoe. So the approach of the family court in these kind of cases has remained fairly consistent for a number of years. Two really good cases to read. The first one is Reeve. This is a useful introductory case to read, and in particular, Williams J's review of the legal framework. Reeve remains the leading case in these kind of cases, and it sets out the approach which is on the next slide, please, Zoe. So this is the approach set out by Reeve, and I'll just go through it relatively briefly. So the only principle that these cases should be decided on is in accordance with the welfare of the child and the welfare checklist. The presumption of parental involvement, unless there are safety issues, so section 1(2)(a) of the Children Act, means that there's a heightened scrutiny required of proposals which interfere with the relationship between a child and their parents. The guidance in pain is only guidance. It may assist a judge to identify the potentially relevant issues, but only as part of this overall assessment of welfare. In assessing a child's welfare, the court will undertake a global holistic welfare evaluation to determine where the children's interests lie. So that means analysing each individual welfare option before the court and weighing its internal positives and negatives. And each option is then compared against the competing options, and the judge will make a decision based on the circumstances of the case. There isn't any presumption in favour of either parent. The court must also take account of the Article 8 rights of the child to maintain direct relations and direct contact with both parents on a regular basis, unless it's contrary to their interests. And there is also the Article 9 of the UN Convention of the Rights of the Child, which will take into account. The court should not overlook the Article 8 rights of others affected, such as the parents, and the court should balance up the competing rights. Of course, the further removed from the parents and the child the individuals affected are, the less their rights are likely to be infringed, and so the less weight will be given when the court is doing their comparison. So I think we're on the next slide, please. So looking at this global holistic welfare evaluation and trying to think through what does that actually mean. In Reeve, Williams J suggested that the court consider what may be described as the FKC pain composite. And in doing so, he posed a number of questions. And I think that these questions are quite helpful when thinking about this global holistic welfare evaluation. And those questions sort of add to the questions that Most and J asked in TC and JC. So some of the questions are there. So what may be the impact on the child of the change of their relationship with the left behind parent? How secure is that relationship now, and how likely is it to endure and thrive if the child does move? How realistic are the proposals for maintaining contact? What will be the impact on the removing party of having to remain in England contrary to their wishes? In my view, asking these questions and answering those questions is often a good starting point for parents in setting out their proposals for the court. Next slide, please, Zoe. So now I'm going to go on to tips and traps for defending an application. It's really important that the respondent considers and prepares a well thought out plan for opposing the proposed relocation. The respondent needs to demonstrate to the court the plan to relocate is contrary to the children's welfare as measured against the welfare checklist. And that's why those questions posed in Reeve, I think, are really helpful, a helpful starting point. As part of that, the respondent should really scrutinise the relocation plan and proposals for contact. Can they be shown to be unworkable? Can they be shown to be impractical? I think it's important not to assume that the applicant has done the necessary research or taken the necessary steps. The respondent needs to critically evaluate the applicant's housing and education proposals for the child in the other country and compare them against what's available in this country. Exploit any lack of clarity or realism in the relocation proposals. Go back to basics and make sure that they're really well thought out and that you can show that they are unworkable and impractical. question motivation. Is this an application which is motivated, even in part, by a desire to reduce contact? Equally, the court will consider whether the respondent's opposition is motivated by a genuine concern for the child's welfare, or is driven by an alternative motive. So the respondent should be really careful in their presentation to the court and any criticism that they wish to raise of the applicant's parenting. It may be counterintuitive to parents, but the recent case of Reeve highlights that if the applicant is flexible and willing to cooperate with the respondent regarding contact arrangements, then this can improve the applicant's prospects of success. In Reeve A, which is a 2020 case, the court noted that the mother had honoured and facilitated contact to date in the most difficult of circumstances, which the court said boded well for future contact, and the mother was granted permission to relocate with the child. So if historically the applicant has not been flexible, has not been willing to cooperate, hasn't honoured or facilitated contact, or hasn't been generous with proposals for contact, then highlight this to the court as something that is likely to have an impact on the child's ability to have a relationship with the respondent if relocation takes place. Convey to the court how difficult it will be for the respondent to maintain a full relationship with the child. How will time spent with the child be affected? Could this be mitigated in any way? The respondent should deal with the question about whether they could follow the applicant and the child and make a life for themselves in the other country in order to maintain a relationship with the child. If there are genuine reasons why this would not be possible, then make sure those are set out. The court will consider to what extent would this detriment be offset by development of the child's relationship with extended family members in the other country. So if there are family members in this country, highlight those family links here. Identify those relationships with relevant extended family members such as grandparents, cousins. Next slide, please, Zoe. Statements read best when the detail is brought to life. So give an example of a favourite way that the child likes to spend their day, describe their likes and dislikes, their interests, and how they're supported by the respondent. Generally, the more balanced the evidence is, for example, about what good things the applicant brings to the child's life and how the respondent can support that input, the more the respondent can satisfy the court that they can be a trusted custodian of the child's welfare. Generally speaking, any criticism of the applicant must be well-founded and balanced. And I think that that's a really careful balance in these kind of cases. Often, or sometimes, the respondent wants to highlight concerns that they have about the applicant's parenting when they get to the stage of court litigation. And there's a balance between that and not wanting to give the court the impression that they would prevent the child having a relationship with the applicant. The court is likely to look at the arrangements at the time within the context of the pandemic as it is at that point, including if there are any restrictions in place in terms of travel, but also once the restrictions are lifted and in a post-COVID world. Think really carefully before the respondent agrees to a temporary relocation, as it can be really risky in terms of defending a permanent relocation. In Reeve C is a really good example of that. And if you've got that kind of a case, and it's worth reading, a child can become habitually resident in another country, even if this is against the wishes of the other parent, and that's worth bearing in mind. And if this is the case, then of course the family court here can lose jurisdiction. Don't underestimate the importance of being able to enforce the order if relocation takes place. The applicant should usually be obliged to secure a mirror order well in advance at their own expense, and take legal advice in the other jurisdiction around that mirror order. And lastly, have a clear workable plan about what should happen if the application succeeds. I think this can be quite a difficult aspect for the respondent, but the court will expect, in my experience, to understand what arrangements the respondent will put in place if the child relocates abroad, make realistic proposals setting out the duration and frequency of the trips back to the UK for the child to visit the respondent, as well as contact through indirect means such as Skype, FaceTime, instant message. And I think that goes back to wanting to persuade the court that you are a custodian of the child's welfare. That you're a safe custodian of the child's welfare. I'm now going to hand over to Alev, who's going to talk about maximising prospects of success in making that application.
Thank you very much indeed, Amy. Those of you who practice in this area will know that relocation cases are some of the most emotive children's cases in the family courts. And you will know that they are some of the most keenly fought cases, and ones in which the margins at which there is victory or loss are often very narrow indeed. What I just want to say very briefly about Reeve is that, in fact, Zoe and I were fortunate enough to be part of the team representing the father who was resisting relocation in that case. And just to perhaps top off the tail of that case, so to speak, the defence was successful, but in a rather roundabout way, because the time spent in the process of appeal and so on did enable, perhaps rather unusually, did enable a process of reflection to take place, and the mother did not in the end pursue her relocation. And of course, the outcome for that child, or young person, I should say, as she then was very different to that which it would have been had the court not intervened in the way, had the Court of Appeal not intervened in the way that it did. But what, of course, Reeve did do, many will say, well, it stated the obvious that this is really all about welfare, but it undoubtedly took the focus away from the plans of the relocating parent, and did bring into sharp and clear focus the plans of both parents and also the child, as opposed to that relocating or intending to relocate parent. So what I'm going to do now is just take you through a few points, and I hope you'll forgive me if some of them are rather obvious ones, but a few points to bear in mind when mounting or preparing an application for a parent who wishes to relocate. Preparation, impeccable preparation, is really key, and it is essential to push every possible positive point to the absolute most benefit that it can possibly give the case, because you can never know whether that one particular extra point might just tip the balance in favour of the relocation application. So first of all, a few pointers about the statement in support. This will be the most crucial document that the parent who seeks to relocate will file in the case. It needs to be a very detailed document, a full document, which sets out in the fullest possible detail what the proposal is. So it needs to address issues such as accommodation. Where is the parent going to live with the child? Who is going to be part of that home? What job is that parent going to undertake? Is there going to be a suitable income to maintain the parent and the child? What thought has been given to schools, contact proposals, support networks, family, friends, and of course, most importantly, what is the proposal in terms of time that the child is going to be able to spend with the other parent? Statements in these cases are generally quite large tomes, and there should be an attempt to avoid any curtailment of that by directions that impose a page limit. I have come across recently an attempt to do that. I think it's probably the sort of case where it can be resisted more successfully than others, but there does need to be an ability to provide a lengthy document, and the exhibits to that document are, of course, going to be quite crucial. Generalities in that statement need to be avoided in favour of specifics. So, for example, rather than an assertion that there are a number of good schools in the area, it is going to be far more important to say, actually, these are the schools that I have approached. This is the conversation I have had with the head. This is what makes me think that for our child or children, this is the right school that will best meet their needs and enable them to thrive. So those sorts of specific and bespoke, if I can put it that way, sort of presentations about schooling are far more important than simply, oh yes, well, there are plenty of good schools that are near where we want to live. The plans that are set out have to be realistic. They have to be practical. They have to, if possible, look very closely at and head off and anticipate all the arguments that will be raised that the move is going to harm the child. and the ways in which that harm or any losses that the child will suffer can be ameliorated will have to be addressed. So that harm needs to be set against the positives or the gains. And again, a very obvious point, but a visual tool is always an attractive one. A bit of colour in there too will make it even more attractive. So a tool which clearly sets out what the advantages and disadvantages are. It will always help, even if it just simply on the first reading places in the judge's mind a very clear idea of a balance being tipped in favour of the relocation rather than against it. And of course, the statement is one that, if it is in the polished and detailed form that it hopefully should be, it is not only going to create a good impression on the judge, it is going to display insight, it is also going to be important for whoever the court has appointed to prepare an independent welfare report in the case. Motivation. Now, Amy, of course, has already spoken about motivation from the other side of the coin, but for an applicant, it must also address motivation very clearly. And what will need to be demonstrated, of course, is that the reason for moving has nothing to do with seeking to diminish or disrupt the relationship that the child has with the parent who is going to be left behind. And a history of trying to prevent or obstruct contact is obviously not going to be helpful in that regard. May I trouble you, Zoe, please, to flip us over to the next slide. Thank you. So, developing further what needs to be demonstrated in terms of the contact proposal, there needs to be a demonstrable commitment and plan for regular contact, but not just time spent together, but how that relationship can develop with the other parent. And that is particularly important in the case of younger children whose development or whose relationship may still be in the stages of being formed. And leaving aside issues about whether, in fact, for children of those sorts of ages, a relocation application is going to be more problematic, there is perhaps a need to be more imaginative. It's particularly important, for example, to look at, well, what use can be made of all the various ways of communication and staying in touch that we have, for example, Skype, telephone contact, video contact. How can that be sustained? How can that be meaningful for younger children? It might be meaningful if it's by way of a call at bedtime, a reading of a bedtime story of that sort, something of that sort, or maybe even an audio file where a parent has recorded a bedtime story that can then be played to the child and so on. So all of those sorts of things, if they can be included and thought about, they will display both insight and a commitment, not just to contact, but to how that relationship can continue to thrive and develop. Conduct in the relationship is a tricky one in some respects, because the focus generally should be on looking forward and not on focusing on the wrongs of the past, because that, of course, then feeds into motivation. And it's important not in any way to present a case that is motivated by wanting to run away from a partner or an ex-partner that is causing difficulties. That said, if there are genuine issues of domestic abuse, they are, of course, going to be relevant and bolster the case for the relocation. I've just given you a citation there for a decision of Mr. Justice Cobb in CB, which is quite an interesting one, because in that case, there were findings made, clear findings made of coercive control by the father, who was going to be the left behind parent, and of failures by the mother who wanted to relocate to facilitate contact. And there was an unusually long period of adjournment in that case of some 5 months, 6 months or so, in order to enable reflection and a sort of recalibration by both parties, for father to address the findings of the court and for mother to perhaps right her obstructive approach to contact. So moving on, the history of contact is obviously going to be an important issue. It will need to be set out in full. The aim in preparing this document for a relocating parent is going to be to demonstrate that it has been consistent, hopefully. It's gone ahead, it's been encouraged, it's been promoted. If the history is a little questionable, then consideration needs to be given to whether contact can be or should be extended pending the court's final decision. A double-edged sword in many respects. The more contact that's given, the more that stands to be lost on relocation. But conversely, more contact demonstrates a generous approach and will bolster the argument that contact will be maintained further to a relocation. So on balance, it probably is always the case that a more consistent pattern, more cooperation and promotion and accommodation of time with the other parent will be to the advantage of the relocation application. Zoe, may I trouble you again, please? So may I trouble you just to move on to the next one? Thank you. Looking at what contact is going to be offered post a final hearing, that is, again, an important factor, of course. We've touched on that already. Other family members might have to be part of that if they're going to be involved in any of the travel arrangements or transport arrangements. A partner's involvement in that, of course, is also going to be a very important factor to address. Evidence of job offers and opportunities. If that is the driver or trigger for the move, then of course it's even more important that that evidence is in tip-top shape, whether it's the relocating parent or the partner's job, then that all needs to be set out. If it is going to be argued that a refusal of an application is going to have a negative impact on that parent's psychological health, then that, of course, should be set out. It does require strong supporting evidence. It will require far more than simply, well, I'm going to be devastated or I'm going to be very upset. Even if it is a GP's letter saying, well, actually, she or he has come to see me suffering with anxiety and so on. If there is some independent documentation, that is going to help. Healthcare needs to be addressed. How is that going to be delivered? What mechanism will there be for making sure the other parent is notified and kept informed? Transparency will be key. There is no question of too much information being given to the other parent. So aiming for information overload might be the way to go. And just to point again to something that is obvious, the plans must be for the long term and not just for the next 12 months or so to tide the child over. Those plans need to take the child through to and show that that parent has thought about how the move will impact the child for the rest of that child's minority. So just very quickly, of course, again, some obvious points. COVID restrictions will have to be brought into the plan as much as possible, necessary testing, airport travel arrangements, and so on. And within that, whether an escort can be provided by the plane company, whether the airport can provide somebody to take a child from the departure gate to the actual gate of the flight, and so on. Visual aids, again, just to touch on that, setting out the division of time, again, in a very clearly digestible way is going to help. The aim is to enable the judge to fully understand what post-relocation life will look like for the child. And above all, it should demonstrate an understanding and insight into the importance of this decision on the child and the impact on the child. I'm just going to move on very quickly to a few general considerations. Contact strategies, do they need to be adapted in the run-up to a final hearing? Is a more accommodating approach advisable? Generally, it is. Should more time be afforded? Generally, it should. The timing of the proposed application, the proposed relocation, I should say, rather than the application, it should fit in with changes or cycles in the child's life, changes of school, whether it's secondary school here or move to high school or wherever those natural breaks occur in the country of relocation. Wishes and feelings of the child, of course, will feed into the overall welfare analysis. They, of course, can be and should be presented to the court by the parent wishing to relocate, but will be independently explored. A dry run or a window shopping exercise, if I can put it crudely that way, consideration should be given to whether that is appropriate. It is not uncommon for there to be a request for a temporary removal in order to take a child to visit a school or have a look at the area where they might live. Of course, much more appropriate with the older child who might be expressing a wish to find out what those options are. But a valuable tool in galvanizing a child's wishes and feelings. Child may wish to see the judge. Of course, that will have to be considered in due course in an application. And then there is the issue of who prepares a welfare report. Is it better to go for CAFCAS, as the court naturally might be inclined to do, a local authority, perhaps unusually, but sometimes it's necessary where they're involved, or an independent social worker? It is a sophisticated analysis that's required, and I don't mean to suggest that CAFCAS cannot provide it, but in general terms, the longer reports, the longer interviews, the more in-depth analysis comes through the ISW route, not least because they have the more available time in which to make those inquiries. So important considerations there. Witnesses, of course, these may be family members in the country where the relocation is to take place. A partner's involvement and evidence is, in my view, quite crucial. And if that is lacking, then it raises the question as to why not, because that partner's ability to promote contact is obviously going to be very important. Time estimates for final hearing, they should always be realistic, because these applications take much longer in the end than anybody perhaps perceives they might, even if there is only mother, father, and independent reporting officer to give evidence. Expert legal advice, registration, enforceability, and so on. There may be a need to look at, particularly at some of the matters that have been dealt with by Roberta and Eleri. Shared decision-making with the respondent parent. It's far better to say, well, actually, these are the schools that I think might be good, A, B, C, and D. Have a look at them. Help us make the right decision for our child. I'd like you to come on an online meeting with the head of the school, or whatever it might be. And then I just finish with 2 points. Be prepared to offer the lion's share of school holidays, and really, don't make the application until all of the issues that I have gone through have been addressed and are in order insofar as possible, because that will help and maximise the chances of succeeding. So thank you very much for bearing with me through a survey of all those points that should help succeed in an application.
Thank you very much, Alev and Amy. I have had a number of questions come in from some very esteemed and erudite colleagues. If I may address this first question to Roberta and Eleri. So this question is there yet any judicial authority with regard to the regime now in force for enforcement of pre-31st December 2020, pre-Brexit EU final children orders? And the question continues, and vice versa, how other EU states enforce English orders. And the questions continued with the 1996 convention applies, but legal aid is very limited, it seems, if this is invoked. Eleri and Roberta, can I ask you about that? Would you like me to repeat any of it?
No, I'm happy to say my response briefly. The legal aid point, I think I touched on earlier already. There was legal aid for recognition and enforcement of orders under Brussels 2A. As I understand it, there is not for the 96 Hague Convention orders, unless somebody told me otherwise. But my understanding is that was a ministerial decision, and I'm sorry about that. In terms of authority, there isn't, to my knowledge, any recent authority dealing with the enforcement of orders now that were made before the end of the transition period. But I suppose one wouldn't really expect anything because they would still be being dealt with under the same principles that they were before. If your order arises out of proceedings that started before the end of the transition period, most of those would be orders made before the end of the transition period as well, then you use the Brussels 2A regime for recognition and enforcement. That's the same as it always was. If you're in the other category where the order is going to be recognised and enforced under 96 Hague Convention countries, under the 96 Hague Convention, there's not going to be any difference in principle with the authorities that already existed for countries where we were already operating the 96 Hague Convention in that respect as well. So going back all the way to 2014, there's case law Reeve, when, as he was then, Mr. Justice Moylan dealt with a case in that regard. So whilst there's not much, there is some authority about recognition orders under 96 Hague, a couple of them Russia. So yeah, there's a bit of help there, but otherwise for the pre-transition period cases, you can look at the previous Brussels 2A case law in that respect. And maybe Roberta can help from the look from the other perspective on the EU side.
I can tell you from the Italian perspective, as far as Italy is concerned, in both cases, you end up before the Court of Appeals for enforcement. The procedures are slightly different under the 1996 Convention or the Brussels II. But in general, the Court of Appeals deals with them rather quickly. When I say quickly, it's always a question of months in an event. So maybe not so quickly, but it is quick for the Court of Appeals that for ordinary cases has a very heavy backlog. And so it works. It works through the Court of Appeals that is quite expert in enforcing foreign orders. And as I said, the procedure is slightly different depending on whether you act under the 1996 Convention because it's after Brexit or under the Brussels II because it is a pre-Brexit or it is in an event in European country.
Thank you very much, Roberta and Eleri. I've got a colourful question in respect of relocation applications, which I'm going to direct to Alev and Amy. And this is about the case of Reeve, which says that, applicant gets into trouble if they've not been flexible or generous with contact. So the question is, aren't applicants sometimes run ragged contrary to the interests of the child by being compelled to incrementally increase respondents' demands for contact? Is there a simple guide for applicants in managing this? Alev and Amy, can you help with that one, the pressure?
Shall I just, is that all right, Amy? I think, yes, there is that pressure. I think this is perhaps one of the more essential points that have to be satisfied, though. And it really depends on what the history is. If there's a reasonable history in place already, I don't think that an applicant should be falling over themselves to afford more time with the other parent. It's really just maybe to take stock, and if there's been a failure or something that is going to work against the application, to try and remedy that rather than anything else.
Thank you. Thanks very much. I'm going to, because we're running out of time, I'm going to have a final question, which I'll open up to anyone to answer. And it was said by Alev during the talk that on balance, it's always better to cooperate and accommodate and promote contact. So the question is, can you ever see a situation where the applicant agrees to the left behind parent actually having more care than the applicant in the run up to a hearing? I think that's a provocative question, strategic in the extreme from my erudite and esteemed audience member. But what's over to you, panelists? I mean, it is a very strategic area of law, isn't it? Relocation, where we're constantly presenting and manoeuvring to get the win or the to win the case for our clients.
Can I just suggest that if for example, there is a a situation where the child is relatively young and you have a father or mother, doesn't have to be a father, of course, but you have the potentially left behind parent saying, well, actually, I haven't had much of a chance to develop my relationship because you've been quite restrictive. I've not had much time on my own. I've not had many weekends and so on. It might in that situation be a very positive thing to say, well, actually, so that the child, once we move, has a much better and firmer relationship with you and will be able to hold that, then here is some more time. Perhaps you can have 4 out of 7 rather than 2 nights out of 7. I don't know. I've certainly had judges suggest that whatever time is left between the decision allowing a relocation and the travel out, that most of that time should be given. But of course, we're talking about pre the hearing. But of course, you've got to be careful not to establish a status quo that tips the balance against the relocation.
Thank you, Alev. And that was a typically child-focused answer from you, and I wouldn't expect anything less.
Sorry, can I just add one further thought to that point, which is this. In terms of the question asking having more care for the applicant in the run up to it, I think the only circumstance I could imagine where that might even be possible in order to avoid the very point Alev makes about changing the status quo somehow might be in relation to school holidays. Because if, as Alev said, you're actually already proposing that the left behind parent would have a sort of greater share of the holidays, that might be an easier way of saying, well, here, I have a bit more of this holiday or this holiday, without actually doing yourself and your plan any harm, whilst looking generous and child-focused and cementing that relationship so that you can rely on the strength of that relationship once the move has happened as being something that can easily be maintained. And of course, then if it goes disastrously wrong and the parent who's being left behind really can't cope with the child for that amount of time, then maybe the judge will find it a bit easier not to give them oodles of time thereafter. But I mean, it's also fact dependent, isn't it? Circumstances of the case.
Yeah, that's really helpful. Thank you very much. Eleri, can you tell us what happened at the end of Charlie's story, please?
Sure, although I don't want to steal the thunder too much from Alev because I started the case and Alev finished it. But I'll do the interim update, which was in relation to the Christmas holidays. Charlie came back for Christmas and did spend Christmas with Dad as proposed. The fight was initially looking like it was going to be about jurisdiction, but we managed to sidestep by that point. We were able to agree for the avoidance of any doubt that England would have jurisdiction just to decide the leave to remove matter, and we didn't need to have a argy-bargy about where the child had been habitually resident before. So we cracked on with the leave to remove, and lots of challenges to consider in the preparation of that case. And as Amy and Alev have covered, thinking about what to put in the statement and how far to go with the various allegations the client wants to make and so forth. But in the end, it was a decision about whether or not the child should live in Italy with mum or with dad in England. So I'll let Alev tell you what happened.
Well, the decision was that the child should remain in England with father. What was interesting, though, was that the judge in that case treated it very much not as a more conventional relocation application, but as a residence fight between 2 parents. And it just so happened, in his formulation, just so happened that one of them wanted to live in Italy and one of them to remain here. But that came also from a background and context of a sort of shared care arrangement. So I think that made it a lot easier for the judge to start off that way, rather than having to decide the residence first, which you might have in a case where there were more of the sort of welfare allegations or issues raised that would militate against the other parent having care. That was not this kind of case.
Thank you, Alev. Thank you, Amy. Thank you, Roberta. And thank you, Eleri. And thank you, Claire, for your support. I'm going to draw matters to a conclusion. It's been great to have so many of you join us tonight, and you'll receive a questionnaire through your email address and also some notes. So thank you for joining us.